Welcome back once again to another edition of Liberty Man. This being February, which is Black History Month, we're going to set the record straight constitutionally of exactly what the Constitution itself says about slavery. But the one thing that you need to understand, and we're going to do a whole segment on this a little bit down the road, because we're starting from present and we're working our way backwards on this one. Instead of starting with 1619, the way people are talking about today, I decided to start with the Constitution and then work back to that date. Because there's a lot involved in this. But I will tell you this, and I'm going to show you in the official records of the debates that slavery was one of the few issues where if they didn't get it right, there would be no union. So with that in mind, we are going to share screen and we're going to go to Joseph Story's commentaries on the Constitution. And again, this is done by the Supreme Court itself. So this is citing original precedent by the Supreme Court. So if you want to know precedent about anything with the Constitution, all you have to do is go to this one work, Joseph Story's commentaries on the Constitution, 1833. And you'll see how everything came to be with what we ended up with in the document, because they go through the good and the bad and the ugly of how they argued back and forth to come up with what they did. So it's just a brilliant work. And for a long, long time, until Harvard screwed it up, this was the definitive textbook for constitutional law. So with that in mind, let's go and see what the Supreme Court has to say about slavery and the Constitution itself. It says here, let me enlarge it. Article 1, Section 9 talks about the powers that are excluded from the legislature or prohibited to the legislature. The Article 1, Section 8 goes through and says the Congress has the authority to do X, Y, and Z. No, Section 9 says Congress is prohibited to do X, Y, and Z. So the first thing that's covered in the prohibitions to the legislature is this. The first clause is as follows: the migration or importation of such persons as of any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation not exceeding $10 for each person. Now, the importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by Congress prior to the year 1808. Okay, so this gave the southern states of Georgia, South Carolina, North Carolina, and I think Virginia on this issue, it gave them 20 years to end the slaves trade in their states. So you're looking at a 9-4 vote here. They could have abolished it 100%, but these southern states argued that our whole society will collapse overnight if we just turn the slaves free. You guys up north have no idea about what would happen if this comes to be. And one of the things that they argued was you can't set free a totally dependent and illiterate people loose on a free market society. Because if they can't read, how are they going to know when they go to the store what the label on the can is for the vegetables if it doesn't have a picture? How are they going to know that they're giving the store owner the right amount of money? How are they going to know if the store owner is giving them the right amount of change? How are they going to read a newspaper? How are they going to read a ballot? See, if you're used to having somebody take care of all your earthly needs and all you have to do is do what you're told, you're not been trained to think for yourself. We have to have time to figure this out. Does that make sense to y'all? So that was the reality of the times. Now, but we're going to go through and see what the Constitution says about it, what the Supreme Court of the United States says about it, people. This is what the Supreme Court of the United States says about it. And if anybody else wants to say anything other than this original precedent, they're making it up on their own. It's their chimerical imagination. It is not constitutional truth. So let's just see. The corresponding clause of the first draft of the Constitution was in these words: no tax or duty shall be laid, etc., on the migration or importation of such persons as the several states shall think proper to admit, nor shall such migration or importation be prohibited. It is in this form, it is obvious that the migration and importation of slaves, see here the word slaves. People say that the Constitution doesn't say anything about slaves. Well, and they're going to explain here why. But there it is in the precedent by the Supreme Court of the United States that this first prohibition on Congress is about what to do with slaves and nothing much else, which was the sole object of the clause, was in effect perpetuated so long as any state should choose to allow the traffic. So this was the free choice of the slave-owning states, whether they wanted to abolish it overnight or they wanted to take the 20 years to educate another generation to be free. The subject was afterwards referred to a committee who reported the clause substantially in its present shape, except that the limitation was the year 1800. See, originally they wanted to do this in 3 years. 3 years. Remember, the Constitution was put into effect in 1789. Well, I guess that would have been 11 years. Instead of 1808. The latter amendment was substituted by the vote of 7 states against 4 and was thus amended. The clause was adopted by the like vote of the same states. So 7-4. Once again, you've got 11 states that are voting on this. Rhode Island didn't show up at all for this constitutional convention. So at the most you would ever have would have been 12 votes. But still, 7-4 is a supermajority. But there again, it had to be unanimous or the southern slave states would have just started their own confederacy, and we wouldn't have had a united 13 states, is what they wanted. They're trying to form a more perfect union, folks. Remember that. The preamble to the Constitution, in order to make a more perfect union or form a more perfect union. Okay. They had already been united and won a war, but now it was time to get down to the brass tacks of what to do now that we're no longer subjects to the British crown. They had to do it together. Now look at this. And I'm going to pick on this guy, Darius Spearman, who's a professor of Black Studies. And I go to YouTube and read and listen to some of his stuff. He quotes quite a few things, but he never goes back to original precedent. He's already got a biased slant in what he's trying to produce. I have no personal vendetta on either way of the thing. I'm a historian. I want to know the history. If you don't like the history, so what? If you like the history, so what? History is what it is, or was what it was. And we have to choose, how are we going to take what they did and either improve on it or go along with it. But when it comes to the Constitution, the only way to improve on it is for 75% of the states to go along with it. So it's very, very hard to change what was originally done. It is to the honor of America that she should have set the first example of interdicting and abolishing the slave trade in modern times. All right, Black Lives Matter. Okay, 1619. It is to the honor of America that she should have set the first example of interdicting and abolishing the slave trade in modern times. So the Constitution itself is an anti-slavery document. And we'll get into that a little bit further as we go along. It is well known that it constituted a grievance of which some of the colonies complained before the Revolution that the introduction of slaves was encouraged by the crown and that prohibitory laws were negative, meaning vetoed. Even before the Revolution began, some of the colonies started passing laws to prohibit the slave trade. You couldn't educate the slaves to be free men if you kept pouring in more slaves at the bottom of the barrel. You had to stop the trade before you could stop the institution. But the crown, the monarchs of England, said no. And we're going to get into that. It was doubtless to have been wished that the power of prohibiting the importation of slaves had been allowed to be put into immediate operation and had not been postponed for 20 years. But it is not difficult to account either for this restriction or for the manner in which it is expressed. It ought to be considered as a great point of favor in favor of humanity that a period of 20 years might forever terminate within the United States a traffic which has so long and so loudly upbraided the barbarism of modern policy. Even within this period, it might receive a very considerable discouragement by curtailing the traffic between foreign countries. And it might even be totally abolished by the concurrence of just a few states. In the Federalist Papers, they said, happy, it was then added by the Federalists, Happy would it be for the unfortunate Africans if an equal prospect lay before them of being redeemed from the oppressions of their European brethren. Let it be remembered that at this period, this horrible traffic was carried on with the encouragement and support of every civilized nation of Europe, and by none with more eagerness and enterprise than by the parent country, England. Remember, I told you we were British subjects until the 4th of July of 1776. We were subject to the crown. We wanted to start abolishing it. Crown wouldn't allow it. We'll get into that. America stood forth alone, uncheered and unaided, in stamping ignominy upon this traffic on the very face of her constitution of government. Stamped on the very face of our constitutional government. Although there were strong temptations of interest to draw her aside from the performance of this great duty. Yet attempts were made to pervert this clause into an objection against the Constitution by representing it on one side as a criminal toleration of an illicit practice, and another as calculated to prevent voluntary and beneficial immigration to America. Nothing perhaps can better exemplify the spirit and manner in which the opposition to the Constitution was conducted than this fact. It was notorious that the postponement of an immediate abolition was indispensable to secure the adoption of the Constitution. It was a necessary sacrifice to the prejudice and interest of a portion of the Southern states. The glory of the achievement is scarcely lessened by it having been gradual and by steps silent, but irresistible. Congress lost no time in interdicting the traffic as far as their power extended by a prohibition of American citizens carrying it on between foreign countries, meaning you couldn't do this with foreign countries. As soon as the stipulated period of 20 years had expired, Congress, by a prospective legislation to meet the exigency, abolished the whole traffic in any direction to citizens and residents. You couldn't bring any more slaves into America, as the Constitution stipulated. But these southern states had still not voluntarily abolished it within their own borders. Mild and moderate laws were, however, found insufficient for the purpose of putting an end to the practice, and at length Congress found it necessary to declare the slave trade to be piracy and to punish it with death. People were still smuggling slaves in. So they considered it piracy. Thus, it has been elevated to the catalog of crimes to this bad eminence of guilt, and has now annexed it to the infamy as well as the retributive justice, which belongs to an offense equally against the laws of God and man, the dictates of humanity, and the solemn precepts of religion. Other civilized nations are now alive to this great duty, and by the noble exertions of the British government, there is now every reason to believe that the African slave trade will soon become extinct, and thus another triumph of virtue would be obtained over brutal violence and unfeeling cruelty. This clause of the Constitution respecting the importation of slaves is manifestly an exception from the power of regulating commerce. Migration seems appropriately to apply to voluntary arrivals. as importation does to involuntary arrivals. And so far as an exception from a power proves its existence, this proves that the power to regulate commerce applies equally to the regulation of vessels employed in transporting men who pass from place to place voluntarily as to those who pass involuntarily. So that, my friends, is what the Supreme Court and the Constitution says about slavery. January 1 of 1808 began at midnight. That was called the Jubilee or Independence Day for the slaves, and it was celebrated by sermons held in the House of Representatives as freedom to the slaves, and it was preached by a Black pastor. And we'll cover that in more detail if we have time later on. But still, that was considered Black Independence Day, or Slavery Independence Day was January 1, 1808. And that's the truth. Now, just because people didn't follow it through to its end does not negate that the Constitution itself put provisions in to end the slave trade. So the Constitution of the United States, therefore, is an anti-slavery document. Hopefully you learned something. Hopefully I was able to stress it enough to you that the United States of America, in its original founding document, the Constitution, was an anti-slavery document. So with that in mind, God bless you. And the next one is even more enlightening as we delve more into the constitutional history of slavery in the United States.